My name is Patrick H. Boone. Nancy and I have lived in Vestavia Hills since 1968, which is 52 years. I've served as our Vestavia Hills Board of Education attorney for the past 43 years. My comments will be brief because what I bring you is real good news. But you will hear me refer to 3 sources of Alabama law. The first thing that I would like for everybody to know is that the state of Alabama, by virtue of the Constitution of Alabama, has total immunity from lawsuits. And that's set forth in Article 1, Section 14 of the Alabama Constitution, that simply states that the state of Alabama shall never be a party defendant to any lawsuit. The second thing that I want to share with you is the Alabama Supreme Court has ruled that both city and county boards of education are agencies of the state of Alabama. The Supreme Court of Alabama, in 2 major decisions in the 1970s, held that city and county school boards are immune from tort liability. Tort liability is when one party commits a civil wrong against the other. Let's talk in layman's language. In 1976, there was a high school football game in Etowah County on a Friday night, and one of the citizens of Etowah County bought a ticket, and the lady was sitting up high in the grandstands. The grandstands collapsed. She fell, was horribly injured. She filed a lawsuit against the Etowah Board of Education, and the Supreme Court of Alabama said the Etowah County Board of Education is an agency of the state and therefore enjoys immunity. So where does that put the lawyers that want to sue people when their students are injured at school? It leaves the school teachers who are supervising these students that attend the schools. In the year 2000, the Supreme Court of Alabama decided what lawyers refer to as the Cranman case. And the Cranman case gives what is called discretionary function immunity to classroom teachers, faculty, and staff. And what that means is that if a classroom teacher or a member of the faculty, staff, or support worker, employee, whatever, if that employee is in good faith, exercising his or her good judgment in following the policy and performing their duties, and makes a mistake and somebody's injured or hurt, then the teacher is not liable. If you get in legal circles, you will hear discretionary function immunity referred to as state agent immunity, qualified immunity, discretionary function immunity. They're all interchangeable. School teachers, when exercising their good faith judgment and discretion, if they make a mistake, you're going to have qualified immunity, which means you're not liable. Let me tell you when you won't have the advantage of qualified discretionary immunity. That's if you do a willful act, if you do something maliciously, fraudulently, or in bad faith, or outside the line and scope of your duties as a teacher, you're not going to be protected by qualified discretionary function state agency immunity. The other thing that the legislature was wise enough to do was to create the Educators Liability Trust Fund. If the sky falls and you get sued, then the Education Liability Trust Fund is going to provide you with a lawyer, and I think that the maximum coverage limit is $1 million. If I were an employee of the Vestavia Hills Board of Education, I would feel very comfortable from a liability standpoint because I know that I have discretionary function immunity, that if I, in good faith, make a mistake and somebody's hurt, I'm not liable. I wish I were in person to where I could take a question or two, but that concludes my comments, and thank you very much.